Kathleen, would you be willing to give us a little overview of what your panel is, and again, who do you think is going to be most interested in coming, and what do you hope they might be taking away from it? What's the schema?
The schema is negotiation, how to negotiate, improving negotiation skills. So this came about through a conversation that Pari Callis and I were having, and Pari's a retired judge, and she's a mediator, and she's with JDR, and we were talking about the idea that attorneys don't necessarily learn in law school, just like Sherman was saying, you know, unless you take remedies, you don't learn about the damages, the most important part of problem solving for your clients. And Pari and I were talking about the fact that a lot of times attorneys don't learn negotiation through education, through law school. Then what do? You learn it through trial, you know, through the practice of law, right? Just trial and error, and you try different things. And that we see a real difference in the range of skills of attorneys that we work with in mediations. So we said, well, why don't we start talking about our own observations as mediators, not as academicians, but just as mediators, of what we think are some good skills, some what we've observed as being good techniques in negotiation. So that's how that got started, and Pari approached Judge Hillier, who's on the JDR panel, and so the three of us have been meeting periodically and brainstorming examples to use, scenarios that we'll go over, and we try to sort of little game with each other to prepare for this. We said, okay, let's, you have to have deadlines. So we said, let's give ourselves a deadline of about a week. We extended it, so about 2 weeks, because we weren't ready. And we each sat down and made our own list of our top 10 ideas. If you could only say 10 things that are the most important aspects of negotiation, what would those be? So I made a list, Pari made a list, Bruce made a list. We promised to not look at each other's. We circulated them all through email, and then we opened them up and looked at them. And the first thing I found interesting was both Pari and I wrote ours with a sort of positive bent of do this and do that, and Bruce wrote his with the never do this, never do that. So we called it the do's and don'ts. Second thing we noticed is that Pari and I had the same list. It was practically the same. There were a couple variations, but so we integrated and synthesized all of these ideas and are going to present those as part of the talk.
Well, one of the things that I really appreciated starting to mediate is you get to see a lot more different negotiation styles. You have more opportunity to see more people negotiating and more different styles. One, there's more cases. When I was doing complex litigation, I'd be dealing with the same opposing counsel for 3 years.
Right.
But also, in each case, you get twice as many negotiation techniques because you have two counsel to watch instead of just one opposing counsel. And I'm always bringing the same thing myself when I'm representing clients. So I don't know. Did that inform what you're able to bring into the do's and don'ts, just seeing so many different styles?
I think that's probably true. Yeah. I also would add to what you're saying that the parties that participate in mediation and their different styles and what they need and what's comfortable for them is something else worth observing and noting.
And class actions don't talk, so we never.
Right.
Okay, so we have a couple of different options here, and we have a number of opportunities. What I'd really like to do is be able to turn this into more of a conversation, and I think Helen is prepared. Again, we're not only, I just got the note, we're not only recording this for a webcast, but it is now live streaming. So there's several thousand people watching. Wave and say hi. Probably not. Anyway, but Helen is available, I think, to take that mic and run it around. If you got a comment or a question, either about what either of the two presenters have said about their programs or the conference generally, or something else, and she'd be available to run it out to you Phil Donahue style so that you can be recorded for posterity. So at this point, if you have any questions, just interrupt. Just raise your hand. We'll get the mic to you, and we'll get the conversation going in this manner. The other thing we can do until somebody comes up with a question, and before I softball pitch some more to these folks, is we do have a couple more John Medina short videos lined up. So if I hear even a grunt of affirmation that way, we'll just have Helen launch one of those and see what he has to say about something else. So any comments or questions about anything that's happened so far? Anything that's been said? Yeah, Sasha Phillips, yeah.
I have a question, Sherman, for you in terms of early mediation, which I'm also very interested in. But how do you structure the process so that early mediation is effective and the parties feel like they have enough information to go into an early mediation? I know that's a very broad question, but
Actually,
if you could give me sort of a
actually, it's not.
summary.
There's several parts to it. You know, the first one has to do with the 10,000-hour rule. If you're dealing with two attorneys that have been around the block, they know what they're going to need versus what they want. You're dealing with somebody that hasn't, they have no idea what they need. So what happens in terms of structuring the negotiation is going to be completely
Can you give us the
different.
10,000-hour rule for those people who might come into this who don't know what that is?
The 10,000-hour rule basically says nobody knows what they're really doing until they've done it for 10,000 hours, basically about 5 years. It's a pretty basic rule that seems to apply to just about everything out there.
Even the Beatles.
Even the Beatles.
It's 1969 they took off, okay.
So it's, there's a lot of different parts that deal with it. The thing that I'm running into the most is attorneys telling me that they don't want to appear to be the weak guy. And I give them the same answer, let me talk to them. And it's real simple. I sit down with them and talk about when I had a larger law firm, we did exit interviews after every trial. Not after every client, but after every trial, after every settlement. And there were just several questions, but the first one was, list all the things that we did that you like. And you know, they're always the 10 same things, you know, except for the bill. But other than that, there were 10 items, but they're all over the map. But we also added one other thing. We also added, what are the 10 things you like the least? And the first answer on every single survey we did, no exceptions, every one was, it took too long. So I can look at some of these people and say, you know, all of us get work by referral. 90% of our work comes from referral. The best referral you can get is when somebody says, my attorney got it done quickly. That's guaranteed new work. So there is a way to talk with younger attorneys. There's a way to talk with everybody about it. I don't have any problems going to somebody and approaching them from, have you thought about this? And sometimes I might not even let them know who's asked me to talk to them first. So there's ways to do it. It can be done. But that first part, the first contact, we've been struggling with it. I've been talking with Judge Nault and a couple of others about how do you create something so that people get involved early. And the court rules are all about process. And the court rules really don't want much to do with having to think a whole lot about it before you get there. It's yes or no, black or white. And the only thing we came up with was that the parties are required within so many months of filing a lawsuit to write the judge a letter telling the judge why early mediation won't work. And that will force them to really sit down and think their way through it. Well, why won't it work? And now you're taking the onus off who's going to be first. But we really couldn't come up with, you know, the usual thing is within X number of days of filing a lawsuit. That kind of stuff really doesn't make them think about it, doesn't make them wonder, why can't we do this early? But having to write a letter to a judge telling them why it's not going to work, they really have to kind of think their way through it. Don't know if the judges want to read it, but it's really going to make the attorneys think about it. So does that?
So the writing of that is the important thing, not the judge reading it.
Absolutely. You know, My favorite negotiating gimmick is let them think it's their idea. And if they have to write the letter trying to figure out why it won't work, it becomes their idea. They own it. It's a lot easier to work with people like that. Is that what you wanted?
Thank you.
Perfect.
Any other questions, comments, snide remarks? Yeah. Right. Fair enough.
Kathleen, would you be willing to share your top 10 list with us?
Oh, sure. I just happen to have it right down here.
We'll make him come to the conference.
So I'll make it, yeah, Jeff wants me to not share too much.
Hold back.
So you come to the conference.
Leave some bargaining
You've come
room.
to the conference before. Are you coming this time?
I am.
Yeah. So, here's one. I don't know how far we'll go in the top 10 because they would take a while, but here's one. Have settlement goals that address underlying issues and needs and develop a settlement strategy to achieve those goals. Now that might seem pretty straightforward, but I do find that there are times where people haven't thought through that a settlement goal is different than, or can be different than a litigation outcome or trying to predict a litigation outcome. So notice that was paying attention to underlying issues and needs. Doesn't mean that you only do that. You know, you also pay attention to remedies, but paying attention to that and develop a strategy. So to develop a strategy, that means as an attorney, you're going to be sitting down with your client and talking this through. I'll pick one more. Understand who the real decision makers are and pay attention to people of influence, not just decision makers. So both things. Understand who the real decision makers are. Who are their people of influence? When we are setting up mediations, you know, we figure out who are all the participants, and we sometimes get surprised even with lots of effort at intake to make sure we know who all's coming and have enough rooms for them and all of that, and then you'll see the brother walks in, or the kid walks into, the adult kid. My personal preference is to include as many people as need to be included if they are people who influence that decision maker. The last thing you want is the influencer to be out of the room, you know, out of the process and getting the phone calls, what should I do about this or that, or second guessing it once leaving. We're looking for a durable agreement, so we want to pay attention to those influencers and the decision makers.